from the international discourse on biodiversity law, we step into the Indian biodiversity legal regime. The genesis and evolution of the Indian biodiversity law is as fascinating, as engaging, and as significant as the international one. It's also, in terms of impact, also having the similar kind of an impact as the international one has. A terrific coincidence. Look at the objectives and the background. Conservation is the primary obligation to be performed and taken care of. Sustainable use is another. Equity in access and in sharing of benefits derived from the use of resource and the knowledges associated with them. These actually constituted the objectives of the international one. Same is here as well. And having been a party to it, the objective is to fulfill that obligation through a legal prescription here. And it's also an exercise in putting together as much as possible all the laws concerning biodiversity. Prevention of piracy, ensuring safety and security or biosafety is another primary concern. And assertion of the sovereign right and interest to the state is something which is paramount in the entire scheme of things here. In terms of the scope and the nature of this law, one must note that this is not a law which exhaustively deals with biodiversity, in the sense that this is a law which, by and large, has an overarching and overwhelming presence. But this is not alone. In addition to this law, we also have forest and wildlife laws, which have been in force in India since long. And so, this law is supposed to be complementary to and not opposed to or overriding anything that's contained in forest and wildlife laws. So together, the biodiversity law, the forest and wildlife laws would constitute by and large the hub of the biodiversity law in India. Another significant feature that you should note in the Indian law is that this is a law which goes even beyond the international one, the Convention on Biological Diversity, both in its extent, scope, and application, because it covers every conceivable genetic material, including genetic mapping, which has an actual or potential value. As far as CBD is concerned, it refers only to bioresources in a fairly general sense of the term by use of the expression genetic resources. Along with forest and wildlife law, it covers perhaps everything concerning life, excluding human genetic material. The law deals with both the resource concerning life and also the associated knowledge and practices and traditions in relation to life and life forms. The other standout feature is that this is a law which recognizes another special group of right holders. The term used here is benefit claimers, a community of people who have been responsible for conserving, protecting bioresources created and holding of knowledges and traditions associated with its use and application. Benefit claimers, not only it recognizes them, it rewards them as well for the services that they have rendered over time. The authorities and their functions in terms of the administrative architecture, it's fairly simple. It's very similar to the pattern that you see in every other central laws, that it has a three-tier governance system. At the apex level, you have the central one, the central government, the National Biodiversity Authority, the nodal agency. At the state level, you have the state government and the state biodiversity board. And at the lower primary level, we have the Biodiversity Management Committee. The central government is the supreme authority which imposes all directions on the National Biodiversity Authority, which is bound by these instructions. And not only that, the central government under this law has the power to give directions to the state government even. It has the rule making power and it has the power of making regulations operable all over India. The central government has the power to develop national strategies for conservation. It has the function of notification and areas of biodiversity importance as biodiversity heritage sites. It has the power of notifying threatened species, to designate repositories for different categories of bioresources, and it has the power to exempt certain bioresources to be out of the purview of this law by designating them as normally treated as commodities. We'll be discussing it a little later. At the central level, we have the National Biodiversity Authority, and in terms of its establishment and composition, it must be considered as a wonderful institution which brings within it both the experience and expertise in different areas concerning life and life forms. Every department in the government, in some form or the other, which has something to do with life and life forms, is represented here. And so are 5 experts who are drawn from different spheres of human activity, have something or the other to do with bioresources. The knowledge is associated with them in law and things like that. They are also part of this National Biodiversity Authority. Their terms of office is a 3 years period, and the chairperson is supposed to be someone who is well versed in this area of human knowledge and discipline and has sufficient experience in this regard. And as far as the removal of the members are concerned, it follows the same pattern that one should not compromise one's position while holding this position as a member, should not become an interested party in any of the things that is being dealt under this law, should not have conflict of interest situations, should not be an insolvent, should not be a declared offender or anything like that. And so not only you should be well versed in this area, but should also be of a clean character as to be entitled to be considered to be a member of this particular body. Most of the decisions of the Biodiversity Authority are carried out through the meetings held in the Biodiversity Authority, and it's in terms of the quorum, there is no such fixed quorum as such, but by and large, it requires some members to be present, and since there is no minimum quorum that is being fixed, it can be, under extreme circumstances, in a special circumstance, the chairman, the member secretary, and a few other members can confer and then take a call. Most of the actions of the National Biodiversity Authority, there is a unique feature of this law, of this particular institutional arrangement, is it operates through various committees that it has established. And each of these committees, dealing with different sectors of activities, something to do with endangered species or threatened species, a group that can be there for determining access and sharing of benefits. Like that, different groups are constituted. They're called as committees. And there is a special committee exclusively for agrobiodiversity. And these are really the think tank of the National Biodiversity Authority. And they deal with perhaps everything that the Biodiversity Authority would deal with. And they come up with the recommendations and suggestions to the Biodiversity Authority. And by and large, the National Biodiversity Authority acts upon these recommendations and suggestions that are made by this committee. One of the most democratic institutions that you can ever think of. And it also, of course, has its officers and other employees, having a member secretary and quite a good number of scientists and other researchers who work in this organization. And many of the functions of the National Biodiversity Authority can be delegated to any agency to perform on its behalf, depending upon the kind of proficiency or expertise in that particular sphere, in that particular sector in which this particular law would operate. In terms of functions of the National Biodiversity Authority, this is the real hub of activity. It regulates and grants approvals. We will deal with that in greater detail a little later. It advises the central government and state government, so it's the brain trust in the entire area of biodiversity, and it has another very special power. As the representative of the sovereign country, it can even oppose the grant of intellectual property rights with regard to any of these knowledges associated with bioresources in any country outside India. There are provisions with regard to finance, accounts, and audit that this is a corporate body, has its own independent identity, and it carries on its activity in its own name. It is independent of the members who compose it, and it is subject to the usual governmental requirement of transparency in maintenance of accounts and audit and things like that. And the National Biodiversity Authority would invariably follow the directions of central government. Although it advises the central government, it is bound by the directions issued by the central government from time to time. Similarly, the same thing is replicated at the state level. The state government has similar kind of functions at the state level. It makes rules and regulations to be operable within that particular state, of course, coming within the parameter of the central act and the rules. And the State Biodiversity Board has very similar function of the national authority. It has the same kind of a composition, very representative, full of proficient people, full of experience, and drawn from different ministries and departments. And in terms of functions and powers, very similar to that of National Biodiversity Authority. The only difference is the use of certain terminology that in terms of seeking permission for approval of accessing and making use of the bioresources in India, the process is the same, but the expression used is different. In the case of National Biodiversity Authority, the expression used is you have to make an application of a request for accessing and putting to use a bioresource of the knowledge associated with it. But here it's called as prior intimation about access and securing approvals by the Indians. But in terms of operation, prior intimation has the same application as seeking prior approval before access and securing any kind of resource for different kinds of uses by anybody. The difference between the State Biodiversity Board and the national authority is the national authority deals with international issues, and as far as the State Biodiversity Board is concerned, it deals with the access by Indians. We will deal with that a little later when we get into the regulation part. It also has the similar kind of an obligation to deal with its finances, accounts, and audit as the national one. The most significant aspect of this law, as we can notice, is a wonderful institution that has been created under this law called the Biodiversity Management Committee, BMC for short. In terms of bringing this into existence, the local body has the primary responsibility of constituting this particular body. But once it is constituted, this Biodiversity Management Committee manages things by itself. Although the membership is limited to a period of 3 years as per the rules here, as far as the composition of the membership of this particular body, there is no time limit that has been prescribed, with the result that once constituted, it is bound to be there for all times to come, and by terms, the members can elect their own chairman, who would be in office for 3-year period, and then later somebody else may take that position. If there are any vacancies, once again the local body would meet and then take a call in filling out those vacancies. And this is one body which ought to be consulted by the National Biodiversity Authority and the State Biodiversity Board while taking any decision over the use of bioresources or associated knowledges occurring within its area under its purview. And this is the body which is supposed to prepare and maintain biodiversity registers, And it has one another significant function which even local bodies do not have, and that is the power of levying what is called as an access fee for collection of bioresources for commercial purpose. So anybody accessing the bioresource, they may need the permission from the state biodiversity board or the national authority, as the case may be, but to access and take those resources out of these local permits of this biodiversity management committee, it has to pay a fee which can be levied and appropriated for its own activities by the biodiversity management committee. It also has a local biodiversity fund. The funding will come, and most of the money that is being derived out of the access and sharing of benefits, 75% of that money, either by the center or at the state level, will have to go to this biodiversity management committee. So, when once it is constituted, it becomes the most richest body at the local level. That's the significant feature of this. It will have financial autonomy, and it will also have independence in dealing with many other activities concerning bioresources. A sense of ownership is what is being inculcated in the whole scheme of things as far as the Biodiversity Management Committee is concerned. Let's get into the details of the regulations here. First one, how does one access bioresource or the knowledges either for research or for commercial utilization or for biosurvey and bioutilization? Any individual or a legal entity, a corporate firm or anything like that, which has a foreign element in its characteristic feature. It may be a foreign national, it may be an NRI, or it may be a corporate firm which has certain foreign presence in it. Even one share by a foreigner in an Indian company would rank as an entity with a foreign element in it, and it has to follow the procedure laid down here. It has to apply to the National Biodiversity Authority. The individual or the corporate entity with a foreign element need have to apply to the National Biodiversity Authority for accessing and use of bioresources in a particular form by paying the fee that has been prescribed for that. And after due consultations, the application will be disposed within 6 months period by the National Biodiversity Authority. And the interesting feature of this is the approvals of the National Biodiversity Authority or even the State Biodiversity Board, we will see later, will be in the form of an agreement. So, the approval on what terms? How? This will be negotiated, and then there would be a clear contractual arrangement worked out, and that becomes a binding obligation to be conformed to by the one who is going to access the resources. And so the authority, when once it finds that the obligations that are prescribed in the terms of arrangement between the authority and the party is violated, it can revoke or it can impose restrictions, and it has to clearly spell out the circumstances under which these restrictions will operate, why it is being revoked, with just and proper reasons. It has to decide on that. So nobody can access bioresources for either for a research or anything like that, or even for a commercial purpose, if that individual is a foreigner or an NRI or a corporate entity with a foreign element in it. And the one who has been given that permission, let's assume for doing research, if the person who has derived some information on the basis of such research so carried out upon approval, he has no right to transfer the results of the research the way he likes, because in the terms of the agreement he would have clearly stipulated that why for this research is being carried out and how it is going to be put into application. So the permission that has been given to the person is exclusive, and if there is going to be any transfer of the results of that research, then once again one has to go back to the National Biodiversity Authority for approval. Look, you had given me this right, I got these results, I just would like to transfer it to a third party. Can I do that? NBS approval is required, for which a particular form has to be filled in, and this will be decided by the National Biodiversity Authority within a period of 3 months. There are exceptions. There are exceptions to the third party transfers, and these exceptions are clearly spelled out in this law, wherein it has been found that in circumstances when these transfers are permitted under the rules that are framed under this particular law and that has been conformed to by the party, there could be such a kind of a transfer. Application should be in a particular form, and approvals or otherwise will be given public notice. So people would know who has the permission to do what kind of research and what's the result that is going to be obtained. All that would come into the public domain. And if there is a request for an international collaborative research by this particular kind of an entity, there can be an exemption for seeking and securing approval from National Biodiversity Authority, provided certain guidelines that have been made in the year 2006 in this regard are observed by that party. Then you don't need the permission or the approval of the National Biodiversity Authority. But if the results of the research later lead to a claim on an IPR, intellectual property right, then you have to come back to the National Biodiversity Authority. You have to enter into an arrangement with the Biodiversity Authority, deposit the voucher specimen with the designated repository, and then, after the permission is given, can go for registration under the Intellectual Property Rights Authority. Supposing the collaborative research would involve exchange or transfer of dead or preserved specimen for taxonomic reasons, then you don't have to come to the National Biodiversity Authority. There are several ministries and departments of the government which deal with that. There are in agriculture research, in science and technology ministry, you have certain units that are being created for this particular purpose. Get the approval from the designated departments, and once that's being done, there is no need for coming to the National Biodiversity Authority for any approval or anything like that. The information so secured and so obtained through this exchange cannot be shared, or the results cannot be transferred to a third party without an agreement with National Biodiversity Authority. This has been stressed time and again because many a time these violations occur. Because when permissions are sought, permissions are given for a particular purpose only. And that is the right that you get out of this particular arrangement. But when once it has to be passed on to somebody, it is not just easily transferable. Transfer only through the approval process, the same way in terms of entering into an agreement or anything like that with the National Biodiversity Authority, then only it can be done. And if the results are to be published, then once again you have to require the prior approval of the Indian collaborator, and after acknowledging the contributions of the knowledge holders. Unless that is done, if it is to be published internationally, otherwise it will be a clear violation. Because one is that you need to have the approval of your Indian collaborator who had assisted you. And second, you need to have a very clear sense of gratitude toward the one who has actually contributed to the knowledge base in this regard, and so you have to acknowledge that as well. Generation of new knowledge during the course of implementation has to be reported to the National Biodiversity Authority for the purposes of documentation. Because in the course of research, you think that you follow a particular trajectory of research and development, and you expect certain results to be obtained, and for which you have got the permission. But if something new, unprecedented, or unknown to you emerges, and that new knowledge also should be brought on board for documentation purposes to the National Biodiversity Authority. Supposing there is a discovery or development of a new taxon through project being so carried out, then it has to be reported to the National Biodiversity Authority, and the voucher specimen of the same should be designated to be deposited with a designated repository for that purpose. The reason why all these details are being given, and as you can make out from the slide here, is essentially to ensure that no resource, no research in relation to that No knowledges associated with the bioresources are done clandestinely. Any information that is generated are done clandestinely to be taken out of this country. And so, abundant care and caution is shown in crafting of this law and the rules under this as to ensure that everything is above board, everything with permission, the sovereign right of the state is not in any way affected, and things like that. And on behalf of the Government of India, it is the National Biodiversity Authority which will perform all these functions. Now, what about the regulations for access for the Indian citizens? This is far more simple. In the case of Indian citizens, this can be done only after making an application in a particular form prescribed for the purpose to the respective state biodiversity board. If you are accessing it in the state of Karnataka, then you have the state biodiversity board of Karnataka to which you have to give an application. You don't have to go to the national authority. So for Indians, it is easier. Approach the local, the state level biodiversity board. You don't have to go to the national authority. You know the difference? The difference is between something which is foreign and something Indian is that in the case of foreign, exercise of control and authority is very highly limited. And so much of care and caution taken that you have to go to the highest authority which will decide on this. But here, in the case of nationals belonging to India, then for Indian citizens, it's only after intimation or application to the State Biodiversity Board. There are exceptions provided for that. The exception is that a local community or the people who are followers of a particular tradition or a convention and who are actually practicing the same over a period of time, like the one who has been practicing like a professional, like a Vaid, or practicing the Indian system of medicine like Unani or Ayurveda, they don't need any permission. It is business as usual for them because these are the ones which were actually responsible for number one, valuing our bioresources. These are the ones who found different kinds of uses of these bioresources, and these are the ones who have put those knowledges and their proficiency for the public good. And this has to be nurtured and protected, and for that purpose, they don't need any permission. And the only thing that is required is the state needed to take care of that. Whatever rules that are evolved by the center in determining the share in accessing and sharing of benefits as far as the bioresources and putting their application into different kinds of uses, that will be determined by the center and through a gazette notification that's made available, and the same has to be adopted and applied at the state level by the state biodiversity boards. But in those areas where the national body has not evolved the ABS or the access and benefit sharing mechanism, then it can advise the state government over those aspects which are not covered in the central guidelines. The state biodiversity board can do that, and whatever rules that are created for that purpose are to be implemented by the state biodiversity board. There is a very important provision with regard to application for intellectual property rights, with regard to the application of any bioresource or the knowledge associated with that. For that, there is only one condition that is laid down, that before the patent authority gives the or registered that particular right in someone who is making an application for that purpose, this has to be done only after the National Biodiversity Board has been apprised of this by the applicant and has got the green signal from the National Biodiversity Authority. And so, if you just look at the Patents Act in India, it complements the Biodiversity Act by providing for mandatory disclosure of the application. Before it, the source and the geographical origin of biological material and the traditional knowledge used in the invention. So, this is one way of preventing biopiracy. It also provides for pre and post grant opposition and revocation of patent on the ground of or non observance of or non disclosure of or wrongful disclosure of certain information which has misled the authority. Guidelines are issued by the central government for processing applications relating to traditional knowledge and biological material. They provide the patent examiners to check and return the application if the prior approval of National Biodiversity Authority has not been obtained. So there is a very close linkage between the National Biodiversity Law and the Patents Law. The two institutions work together to really ensure that the right holder is the real right, having the right to hold that right, and is not someone who has pushed things under the carpet, hoodwinked at the authorities, and has taken something which should not have been his. And so disclosures are perfectly in order under both the laws. Public notice of grant of approvals are given, and in determining the equity and sharing of benefits, very elaborate provision has been made. The resource, the byproduct, innovations, and practices associated with their use and application, and knowledges relating thereto are taken note of. And this is done on mutually agreed terms and conditions by the National Biodiversity Authority. The wonderful thing about the Indian law is it just does not say about determination of equity as a simple rule. It further follows it up with certain parameters. How do you determine share in the benefits of the conserver, protector, carrier, transmitter of knowledges and traditions in relation to bioresources? For that, in determination of it, the National Biodiversity Authority is to cover a number of aspects, like joint ownership of intellectual property right, maybe that between the holder and the one who is going to put that into application, joint ownership or transfer of technology, location of production and R&D units for the benefit of benefit claimers. These are the people for whose benefit this particular provision has been made. They are the local people, they are the Association of Indian Scientists who have actually been responsible for conserving, protecting, and creating a tradition in relation to biodiversity conservation and protection and management. There is also provision for setting up of venture capital funds. Payment of monetary benefits is also worked out. Deposition of benefits in the National Biodiversity Fund has to be made, and identifiable beneficiaries are going to get direct payment on the directions of National Biodiversity Authority. So the idea is essentially the local community, the traditional practitioner, are the ones who are responsible for the knowledge that has been developed or the practice that has actually propagated this particular life resource is duly recognized and rewarded under this law. Supposing you are not able to identify the benefit claimers, maybe they are spread over several areas and you are not able to identify how many and where they are, then the requirement for the authority is money so derived out of this particular sharing arrangement need have to be used for conservation and protection of biological resources and develop areas where these resources or the knowledges have been from where they have been accessed, and to facilitate the entire overall socio-economic development of this community to which it has been flowed back, detailed and elaborated upon by the central government in a set of guidelines issued in this regard for the first time in 2014, and this evolved in conformity with, as we have discussed earlier, the Nagoya Protocol and ABS. One must notice here that the Biodiversity Act was made in the year 2002 and the rules were made in 2004, and both in the Act and in the rules, long before at the international level, in the Nagoya Protocol of 2010, the ABS system was detailed. But long before that, these were already a part of Indian law. So, this is a law which is so forward looking that how would we determine who shall be able to get the benefit, how much, in what manner, and how do you duly recognize, reward, and incentivize those very people who have been earlier suffering from the denial of something that was theirs. There was that biopiracy, and that piracy is being avoided, and that was done even before at the international level a particular arithmetic in this regard was worked out. That is actually the such a forward-looking legal document that we have come up with in India long before the international community thought of coming up with a formula for that purpose. Several exemptions are there, either from the operations of this law or from seeking and securing approvals for access and sharing of benefits. Like human genetic resources, they're kept out of the purview of this law, or through a gazette notification, if the central government says that those bioresources or that which is derived from the bioresources which are normally traded as commodity. This is under section 40 of this particular act, and if they are listed like that, these do not come under the purview of this law for the simple reason that these are the ones which are in common use, and that which is in common use, vogue, and application, they need not have to get any special treatment as has been provided under this law. Please note that this law is made to only protect those bioresources which are prone to or sensitive to or exposed to number one, abuse, misuse, deceit, clandestine activity, or for such things as to deny what is legitimately our sovereign right or what is legitimately the right of the communities and things like that. There are designated crops and varieties by the Department of Agriculture and Cooperation, and since this is interested in developing Indian agriculture and farmer being the backbone of that, these can be kept out of the purview of this law. Research publications that observe the guidelines of the government and certain collaborative research projects need not have to come under the purview of this. Use of biological resources derived from conventional breeding. See, the idea is to protect those conventions, those traditions and practices. So if resources are derived from such a kind of a method, then they don't come under the purview of this law. Traditional practices in use in agriculture, horticulture, poultry, dairy farming, animal husbandry, or beekeeping. These are also kept out of the purview of strict regimen of this particular law. Local people and communities, including growers, cultivars, local wives and hakims, practicing Ayurveda and things like that, they all are out of the purview of this law. They get protection, but they don't get any obligation. But supposing those traditions and practices and they end as uses of biological resources for commercial utilization, which is not in accordance with those traditions and practices, which is not in accordance with those that have been nurtured over a period of time, like manufacture of drugs, industrial enzymes and food flavors, etc., they are not exempted. They need to go through this very detailed process of regulation, of making an approach to either the central, the National Biodiversity Authority, or at the state level, the State Biodiversity Board, for the necessary approvals in that regard. Any application made under the Protection of Plant Varieties and Farmers' Rights Act for any right under that law, it is exempt from the provisions of this particular provision that is concerning sharing of benefits, concerning intellectual property right, for the simple reason there is an alternative that is already in existence parallelly to the intellectual property regime under this particular legislation, and so it will operate under that law. Indian citizens are entities accessing bioresources for purely for the purpose of research, biosurvey, and bioutilization for research in India, exempt from the requirements of access and sharing of benefits. They may have to make a formal application for permissions. Other than that, they don't have any obligation for following the requirements of access and benefit sharing requirements. Now, supposing there is a dispute, supposing there is a grievance with regard to the decisions that are made or the contractual arrangements entered into, how do they get redressed? What is the mechanism here? This is a unique law. It does not go by the usual kind of a conflict resolution mechanism that we have, that you go to the trial court, you go to the district court, you go to the high court, and then to the Supreme Court. None of that. In fact, basically, the idea is essentially to put everything on board through arrangements and contractual arrangements, through informal consent processes, through consultative processes. So with the result that you anticipate and avoid conflicts. See, when there is a dialogue, sorting out differences becomes far more easier than you being prescribed certain norm and non-observance of which may lead to confusions. Clarifications can be sought, and accordingly you can adjust your kind of activities there. Enough abundant scope has been provided under this law for that particular purpose, and that's indeed a standard feature of this law. It's a very fairly well structured governance system, and it's very inclusive, and every conceivable interest group and every conceivable department and ministry is having some kind of a relationship or the other over the subject, are being brought within the whole scheme of governance, consultation, consensus building, decision making, including the one who wants to access, he will enter into a contractual arrangement. And normally, when you have that kind of an arrangement, the conflicts are kept to the minimum. But still, if within the organization itself there are conflicts, supposing there is a conflict of jurisdiction between one state biodiversity board and another state biodiversity board, then the National Biodiversity Authority will be the umpire. It will decide the dispute between the two. But supposing there is a dispute between the National Biodiversity Authority and the State Biodiversity Board, or if there is a conflict between National Biodiversity Authority and even the central government, and if that were to be there, then the only recourse is to appeal to the High Court. Or, after an amendment to this law in the year 2010, when the National Green Tribunal came into existence, the appeal will lie with the National Green Tribunal, which is a special adjudicatory body to deal with environmental issues. To that appeal will go, and their decision is on par with and in no way less than that of a High Court. Of course, appeal will always lie to the Supreme Court from that, but this is the scheme of grievance redressal and conflict resolution. In terms of penal sanction, this is a very important law. Every authority listed here, the National Biodiversity Authority or the State Biodiversity Board, when they issue orders of approval, their orders, just like that of the court of law, these are all quasi-judicial bodies. They are not ordinary administrators. Apart from implementing this law, apart from administering these aspects of the law, apart from entering into arrangements, the orders issued have the same force as a judgment of a court of law. And so, violation of that would actually lead to severe penal sanctions. And these are not compoundable offenses. Violation means penal action. Very strict law. And so, anybody who comes within the purview of this law should take care, should ensure that one would always remain on the right side of the law and not violate it under any circumstance.